Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. I wanted to alert you to the fact that the clerk of court has now released on June 6th, 2025, a filing entitled Motion to Seal State's Objection to Defendant's Offer of Proof regarding alternate perpetrators and defendant's evidence in support of offer of proof regarding alternate perpetrators. This document has been signed by Attorney William Thompson, Latah County Prosecutor's Office on behalf of the state. It reads as follows. Comes now. The state of Idaho by and through the Latah County Prosecuting Attorney and hereby moves the court pursuant to Idaho Court Administrative Rule 32G1 and Idaho Code Section 74124B for an order sealing the state's objection to defendant's offer of proof regarding alternate perpetrators and defendants' evidence in support of offer of proof regarding alternate perpetrators and the attached exhibits thereto. All of those filings, ladies and gentlemen, are under seal. So the public is not aware of how weak or how strong these offers of proof are in this case, unfortunately. The state then says this motion is made pursuant, and then the rule is repeated as is the statute, because they are previously already sealed or are redacted. Respectfully submitted the 6th day of June 2025. A point here, the defense also raises this when seeking an order on occasion to seal something or other. They will say, as the state is here, because this is already previously sealed or are redacted. Nothing about offers of proof is redacted. Everything is completely under seal. And so now we see the state asking the court to seal their objections and their responses. And if you look on the docket on the 9th of June, you will see the court order that Judge Stephen J. Hippler rendered, granting this relief that has been sought by the state of Idaho. Recall, a motion is an application, a request for a court order for some remedy or some relief of some kind or another. Here it's to seal their response in opposition entirely to these offers of proof of alternative perpetrators. So now both sides' filings are completely under seal. We await a reply from the defense because, recall, the briefings regarding any matter that we've seen in this case, whether it's a motion to compel discovery, whether it was a motion to suppress evidence, whether it was a motion for a Frank's hearing, whether it was one of the multiple in limine motions. Everything starts with the originating motion. Here it's the offers of proof of alternate perpetrators. Then there's a response. That is the second document in the sequence. We see here the state has filed their response under seal, opposing whatever the defense has filed. And then there is the reply. The reply responds to the response. It is not an opportunity for the originating party to re-argue their entire case, soup to nuts. That's what the motion does. The other side's due process privilege to be heard is then the response. And now they can go ahead. They don't have to, but I believe they will file a reply to try to persuade Judge Stephen J. Hippler one more time in writing prior to the hearing to grant them the relief of being able to raise these alternate perpetrators. At the trial, a defense will typically raise it to raise reasonable doubt. There is a hearing that is coming up on the 18th of June on this very hotly contested matter. Unfortunately, the hearing is also sealed to the public. So best we can do is wait for an order from the court following the hearing as to what the court will ultimately rule relative to this matter. We're going to continue to keep you posted as to this issue as further developments arise. Until next time, this is Kathy. Thank you for joining us here today.